No, item number 6, I need some accommodation, my lord. Item number 6, my lord. That will be taken up on 7th of November, my lord. I need some preparation as well as the person who is has filed petition has already expired, my lord. That's regarding retirement benefits and not retirement benefits, promotion benefit, and my lord, I have to examine all that. The person has already expired.
I will adjourn it for 2 weeks.
Lordship.
On the request of Mr. S. Bora, learned counsel appearing for the petitioner, this hearing of this matter stands adjourned for 2 weeks so as to enable him to obtain updated list accordingly.
In respect to item number 8 of today's list, mother. Here, the learned counsel, MS aid Talukdar, her husband is hospitalized. That is, he could not able to come to the court today, mother. So, can it be after 1 week, mother? So that
Item number 8.
8, mother.
Whose husband is hospitalized?
Not husband, the father of MS A Talukdar, the counsel for the petitioner,
Acha, acha.
admitted to the hospital. That is that she rang me and
It is submitted at the bar item 8 that the counsel, learned counsel holding the brief is in the middle of a medical emergency and therefore a request has been made to adjourn the hearing of this matter for 2 weeks. Although this is an old matter, yet considering the ground on which the prayer is made, same stands allowed, list accordingly.
highly honored. I make you mention for listing, my lord. My case is subject matter of the case is for correction of the name, my lord. It may be listed on Thursday, my lord.
Next week.
May I please? No, it's regarding item 5 with a concern of other side. Possibly the matter has become infructuous, so the matter may come up next week.
Matter has become infructuous. So
Almost, my lord. That is why I mean.
No. Infructuous will close it.
I need some time, so my lord, at least.
What has happened in this case?
My instruction is nothing service.
Then we wait.
Request some instruction.
Wait, let the matter be called up. Let us see what is there in the file. Yes.
May it please your lordship. Lordship, I beg to mention for listing of an urgent matter tomorrow, lordship. Lordship, matter pertains to simultaneous proceeding. On Monday, the date has been fixed for hearing of the departmental proceeding, lordship. And if it is continued, then that will cause great prejudice to the petitioner, lordship. Much obliged.
May I please, your lordship? I beg to mention a matter for admission, my lord. Matter has not been listed for a long time, my lord. Last it was on April, my lord, where 3 weeks time was granted to the respondents to file affidavit, my lord. Lordship may kindly
After Diwali.
after Diwali. Always well.
May I pray before lordship? I prayed before lordship for listing a WBC of 2018.
After Diwali. After
My
Diwali.
lord.
After Diwali. Yes, next matter.
May please, your lordship. Also, I beg to mention item number 1, my lord. It may become after 1 week, my lord.
Why?
My lord, there is some part.
You wait. Let the matter be called up.
Yeah, please, your lordship. I beg to mention item number 7. Lordship, the matter may be adjourned for 3 weeks, your lordship. Mr. Achya is not there.
But these are very old matters.
Lordship, 2nd week of November, he'll be there.
No, but maybe, but we are here. The responsibility to decide cases on the court,
Yes, your
not on the lawyer.
Yes, sir.
We will hear and decide it. You be there. Let's see what is the matter.
May I please, Lord. So regarding suspension order, my lord, seeking certain direction, I file IM, my lord. There's some urgency there, Lord. So may I take up this day after tomorrow, my lord?
Friday.
May I be, my lord, one repetition, my lord, is regarding, my lord, selection and appointment, my lord. It was 2022, my lord, and very recently, my lord, I have cleared all this process, my lord. My selection has been, candidature has been declined, my lord, on the ground, my lord, that my SC certificate is invalid, my lord.
So what do you want?
My lord, kindly day after tomorrow, my lord, little bit urgency.
In the first week of November. First week of November.
My lord, motion, my lord.
Motion.
Yes,
Monday.
urgent, my lord.
Friday.
Friday, my lord. My lord, similar prayer, my lord. Pension matter, my lord.
Huh?
Similar pension matter.
Motion.
Yes, my lord.
Friday.
Please, my lord.
Daily list for admission, item 1.
For the timing, my lord. Senior is coming, my lord. Just 1 minute.
Yes, what is the matter here?
My lord, this is a completion and appointment. What happened? They are aggrieved that after 2015, my lord, their case was not considered. My lord will just peruse my lord's order dated 29/24, my lord. The second last order, my lord. 29/24.
Which page?
No, my lord, this is my lord's order, my lord, in the file, my lord. 29/24. There, my lord, already we have placed that their prayer were considered in 2018. And they were supposed to take in instructions, my lord. Means now they have to challenge this new, if they want to, my lord, father challenge, they will have to challenge this new rejection, my lord, of this 2018 SLC. Again, I am placing the same, my lord. My lord, the second page, serial number 4. His case was again rejected in 2018. They will have to challenge this order now. 2015, they are still stuck in 2015, whereas it was considered in 2018.
Case has been rejected.
Rejected again.
My lord, I don't say anything, my lord. Messenger is come.
So that is your problem. The senior comes or not, we are not
It's
supposed to
coming,
wait.
my lord.
Heard Mr. So-and-so learned counsel for the
It will- it
petitioner.
will-
Okay,
it
heard
will-
Mr. R. Learned. You are appearing for
My lord, I am appearing as an additional senior government advocate for all money.
additional senior government advocate, appearing for all the respondents. Full stop. The prayer in this writ petition pertains to compassionate appointment as sought by the petitioner. Full stop. The Yes, Mr. Viswas, your client's prayer has been rejected.
That's true.
Yes.
But actually, we prayed a little accommodation because I have come to know he got a job somewhere. To confirm that I prayed.
No,
for-
that is another matter.
Yes.
Even if he has got a job or doesn't got a, how does it make a difference?
No, no difference. Then I could have pursued the matter.
No. They have rejected the prayer now.
But they have rejected illegally, my lord.
Then you challenge it.
That way I can challenge it
You
now.
challenge it.
Give me that liberty.
That liberty will be there. You're right, Mr. S.C. Biswas. The father of the petitioner, who was working as a grade 4 employee under the respond number 5, died in harness on 28/10/2007, leaving behind the petitioner as one of the legal heirs. Full stop. The petitioner had submitted an application on 26/2/2008 seeking appointment on compassionate ground. And the district level committee of Dhubri had recommended his case for appointment on compassionate ground against a grade 3 vacancy. By minutes of meeting dated 31/10/2008. Full stop. However, in the meeting of the state level committee held on 19/6/2018, is it?
My lord, my lord.
The request made by the petitioner was rejected. Full stop. The petitioner has approached this court by filing the instant writ petition, inter alia contending that the recommendation of the DLC has not been placed nor considered by the SLC. However, the fact remains that the SLC had already rejected the claim of the petitioner. Under such circumstances, unless a challenge is made to the resolution of the SLC, no relief can be granted to the petitioner. Full stop. Situated thus, the writ petition stands closed with liberty to the petitioner to avail appropriate legal remedy as may be permissible under the law.
Deep level noise.
Item two.
Yes.
May I please, Lordship? Lordship, matter relating to family pension, Lordship. The petitioner is the old lady, 77 years old lady. Her son was working in a SSB, Lordship. While working, he was missing in the year 2020, Lordship. After that, she filed a missing FIR, and after she wrote to the authority also. In the year 2020, after his missing, respondent number 3, his wife is getting the family pension, Lordship. Lordship, may kindly see. And
So petitioner's husband was working under which organization?
his not husband, Lordship, his son,
Acha,
petitioner's
son.
son, Lordship.
So under Ministry of Home Affairs,
Lordship.
as what? He was working as
SSB, Lordship.
SSB. So now the retirement benefits are being given to the wife, widow.
Wife, Lordship.
But is there any provision under the rules?
We follow the CCS 54 because wife name was nominated, Lordship. That's why.
But is there any provision in the rules to split it, to give a part of the?
There is some.
Lordship, the rules has been amended, Lordship, in the year 2021. And in the amended rule, there is a provision, Lordship.
So the mother was wholly dependent on the deceased,
Lordship.
no other son.
There are two sons,
Ah.
but she is living with him, and two sons are one have a small shop and one is a salesman. Lordship. They have their own family.
And what about the widow? He has left behind any child?
There are two children, Lordship.
What is the amount of pension?
Don't have idea, Lordship.
Now the mother is living with the widow.
No, Lordship, she is living single, Lordship. She is alone. Now she is bedridden, Lordship.
What is the amount of pension your client is
My lord,
getting?
actually, as per Annex D, my lord, page 20 kindly see, my lord.
Sorry,
Page 20,
page?
20, Lordship.
20.
Mm-hmm.
This order is issued by the commandant adjacent 44 PN SSB narcotic.
So your client does not fulfill this requirement, no? If the
Lordship,
government
as
says-
per new amended rule, there is no need to nominate the.
No. If the government is solely dependent on the government servant and the deceased government servant is not survived by a widow or an eligible child.
Lordship.
So is survived by a widow and eligible. So how can you claim it? Because the widow has to survive. She has two
Lordship,
children.
he has two children also.
She is remarried? No.
No, he is not married.
And she is 19,600 per month.
A small amount may be given.
No, but then
Only last
the
occasion.
two sons are there. They will have to take care of the mother. No? The mother is taking care of the two child and let the
Logic.
two sons take care of the mother. That is the way out. What to do? What is the point in taking out 3,000 rupees from there? It is neither going to help her nor. And in any case, the rules are not supporting your case.
Lordship.
Rules do not support your case.
Lordship.
Then
Unlike the Pronam Act, Lordship, unlike the Pronam Act for the state.
state Assam has an act.
Fact.
Hmm? You have annexed the rules here.
No, Lordship, I have not annexed.
Hmm. So what can be done? Are you willing to give something?
My lord,
On various occasions, the court had directed to
Yes, my lord.
Take
Court-
instruction, Lordship.
Court already directed to say file affidavit in favor of the respondent number 3, my lord. So many times I tried to contact with the respondent number 3, but she did not any reply to me, my lord. Therefore, thereafter, my lord, I also sent a letter, speed post letter, my lord. No reply has been given, my lord. How I file this affidavit, my lord? Anyway, but you see, if she is not willing, then nothing can be done, but the rules are not supporting your claim. So,
See, the old ladies are, Lordship, some amount
old-
maybe.
now how can the, unless she agrees, the court cannot
I
direct.
agree, Lordship.
Court
I
cannot
agree.
direct because the directions can't be. See, Reed Court cannot issue a direction which is contrary to the rules.
Lordship.
The mandamus can be issued to compel performance of duty as per rule. It can't be that rule says that you do something. Whom do you direct? You can't direct the authorities to act contrary to the rules. That's not the court's function. So tell me what to do in your case. Actually, mother is not entitled for pensionary benefit or pension, my lord. But that's right, you take your seat. Those things you don't need to. I am asking you, you are not in contact with your client. No, not. Then you take your seat.
If otherwise, PCRG and lip salary paid her about 10 lakhs. From that, if certain amount is paid.
10 lakhs has been paid.
As PCRG and lip salary. We have stated in our affidavit, page 29, Lord, page 29.
So mother is bedridden.
Lordship.
What will she do with the money?
She will survive, she can take the medicine, Lordship.
Mother wants or the sons want the money?
Lordship.
Mother doesn't even know whether there is any money. $50,000 we can give her. And if
Already she has been
Huh?
maybe given.
Sorry?
Maybe given.
There is a mother. If the amount is not paid, it will be deducted from the pension. That's all.
Lordship.
Heard Ms. D. Bosujari and counsel appearing for the writ petitioner. Also heard Mr. B. Chakravarti, learned CGC appearing for the respondent numbers 1 and 2. Mr. A. N. Ahmed, learned counsel, is present on behalf of the respondent number 3. Full stop. The writ petitioner here is the mother of deceased employee. This is government employee, namely late Lohit Das, who was serving under the SSB, Sashastra Sima Bal. Full stop. While on duty, Tapan Das or Lohit Das?
Tapan Das,
Tapan
Lordship.
Das, Tapan Das, late Tapan Das. While Tapan Das was on duty, he went missing in the month of January 2020. And since then, he is traceless. Full stop. Presuming that Tapan Das was, no, full stop. The respondent number 3 is the wife of Tapan Das. And out of their marriage, 2 minor sons, two sons were born. Who are
Lordship, one son and one
one
daughter,
son and one daughter were born, who are both minors.
minor,
Full stop.
10 years and 12 years. Lordship.
Full stop. Since the whereabouts of Tapandas could not be ascertained for a considerable amount of time, by following the provisions of the rules, the authorities had granted DCRG as well as leave salary along with family pension to the respondent number 3. Full stop. The writ petitioner herein is the mother of Tapandas, who has approached this court claiming a share in the retirement benefits accruing on account of Tapandas by contending that she was wholly dependent upon Tapandas during his lifetime. Full stop. Uh, uh, the respondent number 3 has opposed the said prayer by relying upon SR 10-A, then again small a in the bracket of Rule 54 of the CCS Pension bracket rules 1972, whereby and whereunder parents would be entitled to family pension of the deceased government servant only if they were wholly dependent on the deceased government servant and the government servant is not survived by a widow or an eligible child. Full stop. In the present case, as noted above, Tapandas Tapandas has a surviving wife bracket widow and 2 minor children, and therefore, as per rule so and so, the petitioner cannot have any legitimate claim to the amount of pension, family pension received by the respondent number 3. Full stop. Be that as it may, it is not in dispute that the petitioner is at present bedridden and is suffering from critical ailments pertaining to her old age. Full stop. Therefore, although she may not be entitled to share in the family pension under the rules, yet taking note of the overall facts and circumstances of the case, more particularly the fact that the respondent number 3 has admittedly received an amount of rupees 10 lakhs as DCRG and leave salary. This writ petition is disposed of by providing that out of the retirement benefits received by the respondent number 2, a sum of rupees 50,000 shall be paid to the petitioner as a one-time relief to her. Full stop. The aforesaid order is passed purely on equitable consideration and taking note of the fact that had Tapandas been alive, then he would have certainly extended some support to his ailing mother, which she is deprived of at present due to the unfortunate turn of events. Full stop. It is further provided that if the respondent number 3 fails to pay the aforesaid amount to the petitioner within 6 weeks from the date of receipt of a certified copy of this order, then it will be open for the respondent numbers 1 and 2 to deduct the amount from the family pension receivable by the petitioner, by the respondent number 3, and extend the same to the writ petitioner through her authorized signatory. Stop. With the above observation, the writ petition stands disposed.
Much obliged, Lordship.
Item 3.
May I please, your lordship? Lordship, in this case, Lordship, the petitioner is aggrieved by the manner in which the respondent authorities want to conduct the departmental proceedings. My case is this, Lordship, that I have a criminal case pending where the facts are similar to what has been alleged in the departmental proceedings. And if I divulge my defense in the departmental proceeding, then I fear that my trial will be jeopardized. So on last occasion, Lordship, I had relied on the judgment of Captain Paul Anthony and Stanton Toyotetsu, and my learned friend, they relied on the judgment of State Bank of India versus Neelam Nag, where 1 year time was granted, where it was directed that the trial court should conclude the trial proceedings within 1 year. But here, Lordship, I humbly submit that this is not that judgment is not conclusive. Why? Because the facts and circumstances of that case was different, because in that case, Lordship, it took 10 years to conclude that to take the evidence of 18 witnesses. And here, Lordship, in my case, there are 200 witnesses, more than 200 witnesses, and all witnesses are not related to me. So, Lordship, I humbly pray that I may be granted some relief so that my interest may not be jeopardized.
So how is your interest jeopardized?
Lordship, if I divulge my defense in the
You have not filed written statement.
not yet, Lordship. I have not filed my written statement. I was in when I was served with the notice, I was inside the jail. When I was arrested, I was the superintendent of police Karimganj, and I was inside the jail for 3 years. In the meanwhile, I was served with the notice. I had filed a reply, Lordship, but reply in the sense, Lordship, I asked for time, and I asked for the set list of documents. The list of documents were provided to me, but that was not also complete. That is another thing, Lordship. But as of now, they have initiated the departmental proceedings, and if I join the departmental proceedings, Lordship, in that case, I would have to divulge my defense. And if I divulge my defense here, Lordship, then in my trial, it will be the same, because it is on the same set of facts and same set of allegations.
And what is the stage of the criminal proceeding?
Lordship, considerably the witnesses are being examined. It is in the court of the Special Judge Assam, and it is progressing speedily, expeditiously.
So how many witnesses have been examined?
So far, Lordship, more than 20 witnesses have been examined. But Lordship, all listed witnesses are more than 200, but all the witnesses are not related to me. Lordship, what I humbly suggest and praise this is that, Lordship, if we go by the judgment of State Bank of India versus Neelam Nag, where 1 year time was given, Lordship, here also we can adjust like this, Lordship, that the witnesses which are related to me, they can be taken at earliest, and once they are complete, then the departmental proceedings can continue, Lordship.
No, but that is for the prosecution to decide.
Lordship. This is why it came to my mind, Lordship. That's why.
All right. You show me the judgments you are relying upon.
Lordship, on the last occasions also, I relied on Captain Paul Anthony and Stanton Toyotetsu. In Lordship, Captain Paul Anthony, Lordship will find that page 691, para 22.
Paul
Anthony.
Yes.
The conclusions which are deducible from various decisions of this court referred to above are departmental proceedings and proceedings in a criminal case can proceed simultaneously, as there is no bar, and in their being conducted simultaneously, though separately. Second, if the departmental proceedings and the criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is of grave nature, which involves complicated questions of law and fact, it would be desirable to stay the departmental proceedings till the conclusion of the criminal case. And again, Lordship, my point 3, whether the nature of a charge in a criminal case is grave, and whether complicated questions of fact and law are involved in that case, will depend upon the nature of offense, the nature of the case launched against the employee on the basis of the evidence and material collected against him during investigation, or is reflected in the charge sheet. 4, the factors mentioned at 2 and 3 above cannot be considered in isolation to stay the departmental proceedings, but due regard has to be given to the fact that the departmental proceedings cannot be unduly delayed. So Lordship, what I'm suggesting is that it should not be delayed, Lordship, but at least I may be also protected, Lordship. And it was this thing was again, it was again discussed, and in the case of Toyotetsu, good going.
Yes.
I think extra copy I have given it to Lordship. In Stringent Toyotetsu versus
You have given your copy, Sims. You
no,
can-
Lordship, I have
You
one
have?
copy with me.
You have a copy? Yes, which paragraph?
Lordship, in para 17 and 18, Lordship. Oh no, Lordship, I'm sorry. In para 16, last part of para 16,
Yes.
suffice it to say that while there is no legal bar to the holding of the disciplinary proceedings and the criminal trial simultaneously, stay of proceedings may be an advisable course in cases where the criminal charge against the employee is grave and continuance of the disciplinary proceedings is likely to prejudice their defense before the criminal court. Gravity of the charge is, however, not by itself enough to determine the question unless the charge involves complicated questions of law and fact. The court examining the question must also keep in mind that criminal trials get prolonged indefinitely, especially where the number of accused estranged for trial is large, as is the case at hand, and so there are a number of witnesses cited by the prosecution. The court therefore has to draw a balance between the need for a fair trial to the accused on the one side and the competing demand for an expeditious conclusion on the ongoing disciplinary proceedings on the other. An early conclusion of the disciplinary proceeding has itself been seen by this court to be in the interest of the employee. Lordship, we are not shying away from the departmental proceedings, but my contention is this, Lordship, that I may not be prejudiced in my
All right, you have said that.
so this is my case, Lordship.
All right. Yes.
Well, in the writ petition, their simple prayer at page 15 is upon causes that may be shown after hearing the parties and upon perusal of the records, be pleased to make the rule absolute by quashing the departmental proceeding until the Honorable Court of Special Judge Assam comes to an end of the ongoing trial, and or to pass any order appropriate, the other appropriate order or direction as your lordship may deem fit and proper. So their prayer is that until the criminal case gets end.
What is your stand on the legal issue? Forget their-
On the legal issue, Lord, the Nilam Nag decision, Lordship, it has been placed before your Lordship, Lord. In the Nilam Nag, Lord, the Honorable Court has further considered, but because on Nilam Nag he has said that it was on a particular, the fact of that particular case, it was to trial continued for 16 years. Well, this case has been again, the position has been again discussed with the Honorable Apex Court. In the subsequent case, it is reported in 2023, 10 SCC 675, State Bank of India versus P. Jadenga. Well, it's
the not
details. But the position is logic.
You will cite your judgments, the court will consider.
Malad.
That's not a problem. Try to understand what is the core issue here.
Malad.
Don't crowd your mind beginning with judgments of Supreme Court here and there. Try to understand what is the issue. Issue is saying is that you have lodged an FIR, a criminal trial has commenced against me,
Logic.
which is grounded on same set of facts, similar allegation,
Logic.
which is involved in a departmental proceeding. So when this criminal trial is in progress, where the prosecution witnesses are being examined, if I file my written statement making my defense clear, then undue advantage will accrue upon the prosecution, which is to the prejudice of my interest. That is his sum and substance of his grievance.
That is his.
The law is clear that there is no blanket bar. It can proceed.
True.
But the courts have cautioned that if the facts indicate that there is a grave nature of charge where complicated facts in law and it could have interlinking, then it is advisable to stall the departmental proceeding, but a balanced approach has to be taken.
Lordship.
That's the sum and substance of
That
the
is the
matter.
sum and that is
You
the
can't
sum and
argue
substance. Lordship.
outside this.
Lordship. That is-
Regardless of every judgment is delivered on the facts of that
That
case.
is the position.
Now,
That is the-
he is saying that my case fits into the ratio of this decision because it is the same set of facts. I'm facing a criminal trial. Give me some respite. I will file my written statement after the criminal trial reaches a particular stage. So you suggest something.
The reply he has filed to the show cause notice. But we have in our affidavit, we have said that the show cause notice was given to him. He has filed his reply. And
No, but that is not the written statement to memorandum of charges. These are two different things.
but after receipt of his reply, the departmental the inquiry officer was appointed.
Oh, Mr. You are not, either you are not understanding or you are not trying to understand. Show cause notice is to say why we should not initiate departmental proceeding.
No, in fact, in the affidavit, charge sheet has been issued.
That's right. So has he submitted a written statement against the charge sheet?
But after the
Oh, Mr.
Just-
Nath, don't unnecessarily don't waste court's time. Either he has submitted his written statement or he has not. Has he submitted his written statement against the memorandum of charges?
affidavit says, my lord, he has filed his reply, the authority being found not satisfied, they have appointed, they have
You are
decided.
aware, this is not this is a show cause to asking him why a departmental proceeding should not be initiated. Then a memorandum of charge is given and then the proceeding is initiated, then he has to submit his written statement of defense.
But the with statement of allegations and all this list of witnesses, he has been charged.
All right.
He has been
What was the
served.
argument? You are not answering the questions. You are not submitting anything on the relevant points. You are going here and there. Here and there in this
No,
court,
my-
it will not help.
No, my respectful
You have to hit
submission.
the nail on the head.
My respectful.
Tell
submission-
me something which is balanced and which is not prejudicial to either side. Other arguments will not hold water in this court.
No,
I'm making it very
my simple submission is, my lord,
Hmm.
as regard the charge sheet,
Hmm.
my submission is that charge sheet has been issued, he has replied to that. That is my submission. And my lord, statement of allegations along with the charges and the list of witnesses have been served and it is annexed in the affidavit in opposition. And my lord, after the authority found his reply not to be not satisfactory, they have decided to go ahead with the departmental inquiry and appointing the inquiry officer. At that stage, the honorable court order was passed to postpone the DP. That is the position. That is the factual position, Lord. And
So
the
now you want to proceed with the DP.
we want to proceed with the department.
Why should we allow you to do that?
Lord, my submission is, Lord, that the law as Lord, has been held by the honorable court in the case of state SBI versus Nilam Nag, and further it was Lord, reiterated in the subsequent decision is that simply the criminal proceeding is not a bar, and Lord, the lordship has already.
Mr. Nath, this is, I'm a little disappointed. You are telling me what I just told you.
True.
Do you have anything substantial
No,
to
but
argue?
if the last decision, the decision of that.
You
that-
tell me on facts. Is it grounded on the same set of facts? If it
But-
is, we are going to stay till the witnesses are examined.
Malad, the entire all the case laws, which are those are all Malad, on the basis of the same instance, Malad, same Malad, the same instance, the both criminal and the departmental proceedings have been initiated. And of this decision, Malad, they here Malad, the court has in paragraph 23, Malad. But in these decisions, the honorable court has laid down some guidelines that if those are satisfied, then the criminal proceeding as during existence of the criminal proceeding, the departmental proceeding can go ahead. In the Nilamna case, that was the consideration. Here also, kindly see the case was registered. Case FIR was registered in 2020, and the charge sheet was filed in 2022, in the month of May. Now the trial is going on, and 200 witnesses as are there.
Well, this trial will take a lot of time, my lord, may take years together, but the departmental proceeding, if the department is precluded from going ahead with the proceeding, my lord, ultimately it will not be in the interest of the department as well as the delinquent also. That is the position of law, my lord. That is my respectful submission, my lord.
Okay. All right, anything else you want to add?
Well, from para 18 to 23 and of 30 and 31 of this the decision that
Right.
that may
So,
kindly-
Mr. Nath, you see, the problem is, it is not difficult to pass an order, but the court is conscious that this kind of matters, there could be quite a few in number.
True.
And unfortunately, the answer you have given, the address you have made to the court doesn't appear to be convincing at all. You are just mentioning what is there in which judgment. We wanted to know substantively what is the stand of the, a state cannot just be cannot put up a perfunctory stand. That this judgment says that judgment says that, so allow us to continue. Otherwise, this is not the answer I am looking for. I am saying when this kind of situation arises, what is the way forward to ensure that the accused also does not suffer any prejudice, and at the same time, the department is in a position to enforce the legal provision.
My
You are
information
not giving any answer.
my
So
info-
we would like to hear Mr. Dilip Mazumdar if he is around.
No,
Can you
my-
call him?
well, my information is so far 23 or 24 witnesses have been examined. It is the submission of the petitioner also that all the witnesses are not against him. If malad, the witnesses, he can also malad, place it before the honorable court, malad, that these are the witnesses. Again, they have made some statements against me. If they are already covered, the departmental proceeding can go ahead, malad.
So
I'll also find it
so
out.
you obtain instruction,
I'll also
say
find it
that.
out. I'll also find it out.
That is a reasonable way forward.
I'll find it out.
You are just mentioning what is there in which judgment. That's not going to come to the facts.
Lordship.
Yes, once the witnesses who have testified or who are about to testify against him, their statement is recorded, then his arguments will fall flat.
Lordship.
Then you say that. You
Let
file
him-
your affidavit.
Let him also, I'll examine, my lord. I'll also take the instruction. Let him also say, my lord, who are the witnesses, because 24 witnesses as per the already.
24 witnesses altogether.
No, 200 witnesses, 200,
No, no.
all not, all,
24 witnesses have been examined altogether or 24 against him?
no, altogether 24.
Altogether.
Altogether.
I have to see that who are against who has made a statement.
Actually, now supposing he names X number of witnesses and you agree with it,
Lordship.
who will decide in what order these witnesses will be examined? Because ultimately it is the state which is the prosecuting agency.
That's true. That's true.
The only issue here is question of prejudice, nothing else.
True.
The DP will happen. The trial will also happen. Only question is how to sequence it so that neither side suffers any unnecessary prejudice. So what is the solution? Tell us that. No point mentioning about this judgment, that judgment.
No, while taking the instruction, I'll also take that what is the order, because when I get the information that these are the witnesses against him, so what is their serial number or something that I'll also get, and that I'll take.
So you have understood what I'm saying?
Yes, yes.
Otherwise, those arguments I'm not.
Well, in fact, Mullah, suppose some charges are there, just indicating one point, Mullah, is no prejudice will be caused, because I'll take your lordship to that also. He has obtained a SIM.
Mr. Nath, you
Lordship.
have to see, we understand you are the government counsel, but you have to rise above and address the court on the real legal issue involved here. Otherwise,
I'll take the
how do we take it as an assistance to write a good order? If you
I'll-
merely refer that in this is said, this is there, so don't pass it. This cannot lead to a good order. You have to give us the assistance. And we have to balance out the interest of the state
definitely,
also.
definitely. My entire
And
endeavor is
he
that.
has come up with a solution that you examine the witnesses against me and then I will submit my written statement. If you have a good reason not to accept it, tell us. Otherwise, we find it's a reasonable stance.
No, that my lord, I also.
So that's the only point here.
Lordship.
There's no need to write a 60-page judgment on this or a 100-page judgment. What
No,
is the point? These
just-
principles have already been laid down in the earlier judgments.
True, my lord.
So what do you want to do?
I want to take the instruction, my lord, that who are the witnesses? Let him also indicate, my lord, who are the witnesses according to him. Otherwise, just if he changes the
So
position.
will
that
you
will-
file an affidavit?
We have filed the affidavit, but that has not been indicated. I'll indicate that.
So you want to file an additional?
Yes, we'll file the
So
additional.
why don't you file it? We'll go by you, your stand, you're the state.
No, it is his submission also.
No, no, who are the you are the prosecuting agency.
Yes.
You know who are the witnesses you want to examine against his client. And how long will it take? You tell us.
I'll take the instruction.
You tell us that
I'll take the
we wish to examine this many witnesses
Lordship.
against him. And this procedure is likely to take so many months.
No,
Tell us
Lordship, that instruction I'll take. my lord.
Then if he disagrees, then it's a different thing. Otherwise, we'll mold a relief for the petitioner by giving some time.
Lordship, Lordship.
And you can expedite the recording of
Right.
testimonies also.
Lordship.
But then you have to come up with a stance which can be applied across the board. There are many such cases.
True. Many
Which comes to the
cases. my
court.
lord.
What do you do? If you put a stay once, then it is over. The trial takes 10 years, the stay will operate for 5 years. It's not helping
No,
anyone.
blanket stay, my lord, as they used to pray. That is not the position. That Lordship has ultimately the prejudice thing has to be seen. That will take.
There is a stay order operating in
Yes,
this
stay
case.
order is operating, my lord.
So you take back these judgments. Or you take down. Heard Mr. P.P. Medin, our counsel appearing for the writ petition. Also heard Mr. Dina, Lanet Senior Government Advocate Assam appearing for the stay. After hearing the arguments advanced by Lanet counsel for both the sides, this court is the opinion that before passing any effective order in this case, it would be necessary to ascertain as to the total number of witnesses that this prosecution bracket stay bracket close intends to examine so as to prove the charge brought against the petitioner in the pending criminal proceeding and the time frame which may be required for completing the process of recording of evidence of these witnesses. In view of the above, on the request of Mr. Nath, this matter is directed to be listed again. When do you want it?
Lordship may give me, let it be after 3 weeks, my lord. On
You choose a date,
I'll get
14th,
this
14th November,
14 November.
14th November 2024. So as to enable the learned additional senior government, the learned senior government advocate Assam to place on record the aforesaid information in the form of an affidavit by sending advance copy upon the petitioner's counsel. Interim order passed earlier to continue. I'm deeply obliged, Lordship. Mr. Nath, you have a good look at the issues and
Lordship.
come up with a stance which the court can accept and which can be used for future purposes.
My lord. Oh, my lord.
So anything survives in this case?
How does it transfer? This modified logic has been transferred to Romania now.
He has been transferred, but I have not been allowed to join in Romania by the staff there, my lord. So he may.
Oh, that will file a.
Different.
We'll close it now. Heard Mr.
Yes, they, my lord.
Yes, they learned counsel appearing to the writ petitioner. Also heard Mr. R.R. Gogoi, learned.
My lord, may I just say something, my lord, because now I'm not allowed to join in Romania, so they may again restore this. So that instruction may be brought by him, my lord.
R.R. Gogoi, learned standing counsel, PhD Department, Assam, who has produced a copy of the order dated 1/10/2024, issued by the chief engineer, bracket PHE, bracket close, water, comma, Assam, which goes to show that the transfer order dated 16/9/2024 pertaining to the writ petitioner has since been modified and presently he has been posted as senior assistant in the office of executive engineer PHE bracket close Rangia division against an existing vacancy. Full stop. Mr. Day submits that his client is happy with the order dated 1/10/2024, but the problem is.
I'm not, I want to challenge this also, madam.
Okay, you want to challenge this
Yes, yes.
also?
But now there is no finality as to where I'll be posted. This is the
Mr. Day
letter
submits
written.
that the petitioner would challenge the order dated 1/10/2024 by filing appropriate proceeding. Be that as it may. By order dated 3/10/2024 passed in this proceeding, the respondents were granted liberty to modify the transfer order dated 16/9/2024 by taking note of the submission of learned departmental counsel that the petitioner is likely to be posted at Rangia by modification of his earlier posting. White transfer order dated 16/9/2024. If that be so, this court is of the opinion that no live issue survives for adjudication in this writ petition. As such, by granting liberty to the petitioner to assign the order dated 1/10/2024, if so advised, this writ petition stands closed. You challenge it. That order is gone now.
And if there's any subsequent modification also, that also liberty may be granted.
You're right. And apart from that, if there is any other transfer order issued at any point of time till retirement, all those orders will be stayed.
No, no,
That's
my
the
lord,
order.
that is not because.
Talk like a lawyer. Eh? Don't talk like a
Much
client.
For order item 5.
The order has been literally complied with, my lord. I have some grievances, but that cannot be agitated in this petition. Your lordship may close it.
Mr. M.K. Chaudhary and his senior counsel appearing, assisted by Mr. P. Varadhar, appearing for the petitioner, submits that the order of this court has been complied with for all practical purposes. Mr. Grievance, if any, still remaining. According to Mr. Chaudhary, can only be agitated in a fresh writ petition. Therefore, the learned senior counsel submits that the contempt case be closed. Mr. P.J. Fukan, learned counsel for the respondent, is present and confirms the said position. In view of the above, this contempt case stands closed.
Most of
For hearing item 7.
May I please, your lordship?
Yes. Yes, what is your case?
Lordship, the petitioner was first appointed as the arm branch constable in the year 1980. Then in 1999, he was promoted to the rank of GD Havaldar. On 24/8/2007, the petitioner was placed under suspension along with a show cause notice. Then the petitioner had requested the department for certain documents via letter dated 1/9/2007, Annexure 3 and 4. Lordship then he was then served a second show cause notice on 23/04/2008. Then the petitioner had submitted his response to the show cause notice on 28/4/2008, rebutting and denying all the implications, your lordship. Lordship, impugn order is in Annexure 6.
Page number?
Page number 23. Wherein as punishment, he was inflicted with the punishment of, he was taken down to the rank of Nayak, and his salary was also withheld.
So what is wrong with this order?
Your Lordship, he was punished twice for one offense, Your Lordship. He was then reinstated after 3
Punished
months.
twice now.
He was punished and he was taken down to the lower rank of Nayak. And then he was, his salary was also not released, Your Lordship.
Salary was not released.
Arrears, Your Lordship. No. Arrear pay of, while he was in suspension, the suspension period, he was not paid, Your Lordship. Paragraph
But
number
there is
2,
no
page
prayer
3.
for release of arrears salary. Where is your prayer?
Page number 8, Your Lordship.
Yes.
Uh,
Please read arrears
In the
salary.
premises aforesaid, it is therefore humbly prayed that Your Lordship may be pleased to admit this petition
Where
for
is the prayer regarding release of arrears salary?
quashing and setting aside the impugn order dated 29/05/2008 passed by the respondent, being arbitrary and illegal. The consequential benefits of the petitioner for the period of suspension.
He has been given subsistence allowance.
Subsistence allowance he was not given, Your Lordship. There.
Have you submitted any representation?
Yes, Your Lordship.
Where is it?
Appeal, page number 25 and 27. He had written an appeal. Paragraph 3, Your Lordship.
So how this penalty was issued? There was no departmental inquiry. Where is the inquiry report?
Para 9 of my affidavit, Lordship. It is stated that the second so cause notice was served after departmental inquiry, Lordship.
Where is the inquiry report?
Report is not available at this stage.
There is no report. Show cause and then punishment.
No, DP was there. Lordship, it is in, however, the DP drawn up against him will be revived after 3 months if his repeated similar misconduct will.
These are all illegal. We'll set it aside. Absolutely illegal. You argue. Who is this gentleman? How can you do all these things? Which is the rule which allows him to do it? You issue a show cause notice and then say that he is reduced in rank and then DP will be revived. What kind of, is some kind of a bacha or what? Huh? Where is the record?
Record is not in my hand. May call for the record.
Get it tomorrow?
Lordship.
Day after tomorrow.
Lordship, some
Lordship.
may be given. Lordship.
What is your problem? Huh?
Next week, Lordship.
All right. On the request of Petitioners Council, this matter stands adjourned for 4 weeks. The learned government advocate Assam to produce the records on the next day.
No.
You are about to get a good order which you have missed out. Move.
Much obliged, Your Lordship.
I don't know it.
Lordship, here in this matter, Lordship, similar matters were dismissed by coordinate bench of this court, Lordship. I do not have the number right now. Let it come after a week, Lordship.
What is he saying?
That similar matters has been dismissed by this court. He doesn't have the number. He will produce it
Let it
next
come.
week.
Let it come in the next week.
What is the matter about?
My matter of 2015 selection has been challenged. Pending service rule, there was an order by which a particular district-wise selection number should have been given. They have not followed the rules and orders, and they have published for the whole of the state. For the particular district of Nagaon and
This is
Morigaon.
Morigaon.
Are you aware of such decision?
My lord, he said that single judgment has been dismissed. He doesn't have the number.
Day after tomorrow?
Lordship, can it be after a week, Lordship? In the May. Lordship, next Tuesday, Lordship.
Or Mr. P.K. Roger, Learned Counsel for the petitioner, Mr. D. Upamanu, Learned Standing Counsel, Health and Family Welfare Department, Assam, submits that this writ petition is covered by earlier order of this court, whereby similar writ petitions have been dismissed. Mr. Upamanu, however, seeks posting of this matter again on 29/10/2024.
Not on 29th, my lord. 29th I will be out. my lord. Let it be on 30th, my lord.
30th.
30
October.
He says 5th, my lord.
No, 30
13,
October.
13.
So to enable him to produce the copy of the order
Highly.
passed earlier by this court.
My lord.
Obliged, Lordship. Lordship, item 11 and 12 are similar matters, Your Lordship. In item 12, Senior Counsel Mr. K.K. Mahanto sir is on leave, Your Lordship. My colleague will sit in adjournment. Your Lordship.
Lordship, I'd like to pray for an adjournment in this matter, Lordship.
These are very old matters, 2015, 14.
Lordship, my senior is on leave today.
Uh-huh.
Lordship, my senior is on leave today. His name is being reflected, Lordship.
A prayer for adjournment has been made on behalf of the writ petitioners in both these cases on the ground that the senior counsel engaged by the petitioners is on leave today. Full stop. Ms. M. Bhattacharya, learned additional senior government advocate Assam, is present and does not have any objection if the prayer is granted. In view of the above, hearing of these two writ petitions stands adjourned for 4 weeks. List accordingly.
Deeply obliged.
Item 30.
Petition. Lordship, if Lordship may peruse the last order 14/3/2024. Nine. The petitioner
Which matter? What is the case number?
13.
Case number
901, my lord.
901.
you are appearing for?
A petition, AACB. I'm on behalf of B. Chaudhary, my lord.
Where is the petitioner's counsel?
On-
Last question.
Last order. Yes, none appeared, my lord.
I'm appearing for respondent number 8 now.
Last occasion also none appeared.
Yes, Lord.
Last order 14/3 was, you know. Another order. Was about to please obtain instruction in the matter. 14/3.
None appears for the writ petitioner when the matter is called up. Ms. M. Bhattacharya, learned additional senior government advocate Assam, is present on behalf of the respondent numbers
8 and 9, Lord.
8 and 9. Where is Mr.
And W. Ahmed. W. Ahmed on behalf of B. Chaudhary.
Learned counsel representing Mr. B. Chaudhary, learned standing counsel APDCL, is present on behalf of respondent numbers 1 to
7.
7. Full stop. Record reveals that even on the last occasion, the petitioner's counsel had submitted before this court that, before that you write. By filing this writ petition, the petitioner is seeking a writ of mandamus directing the respondents to appoint him as a Sahayak within court, SAHAYAK, bracket close. Pursuant to the process initiated by advertisement notice issued in the year 2013. The prayer of the writ petitioner appears to be primarily based on another judgment of this court passed in WPC number 125 of 2010, which was upheld in writ appeal number 302 public 2010. Be that as it may, the petitioner has not appeared to argue the matter today, and on the previous occasion also his counsel have pleaded lack of instruction and therefore had failed to advance any argument in the matter. First up, having regard to the facts and circumstances of the case, I am of the view that no live issue survives in this writ petition for adjudication. First up, that apart, the petitioner also does not appear to be keen in pursuing this writ petition. As such, the writ petition stands dismissed for non-prosecution.
Item 14.
What is this, wife of the petitioner?
Wife of the petitioner, your lordship. A department proceeding was initiated against him, and as per it took 10 years for the outcome to come. Thereafter, he was exonerated from the departmental proceeding. Thereafter, he was given the promotion of deputy ranger. In the meantime, his colleagues and his juniors were promoted to a post of ranger. So she's asking for the same benefit as per the husband, your lordship.
But how the wife can maintain?
Exactly, your lordship.
You take down none appears for the writ petitioner on call. The petitioner's counsel was absent even on the previous occasion, that is on 24/5/2024, when the matter was posted before this court. First up, Mr. R.R. Gogoi, learned standing counsel, Forest Department, appearing for the respondents, has argued that the wife of a government servant has approached this court by filing this writ petition, seeking a direction for granting promotion to her husband, and therefore the petition is not maintainable in law as well as in the facts and circumstances of the case. First up, after going through the averments made in the writ petition, I find force in the submission of Mr. Gogoi. Be that it is not understood as to how the wife of a government servant would file a writ petition seeking a writ of mandamus in favor of her husband.
The husband expired, your lordship. He expired.
Achha, yes.
Expired.
Oh.
In 2013.
Submitted as so-and-so. First up. However, after going through the averments made in the writ petition, it appears that the husband of the petitioner had expired in the year 2013. Be that as it may, since the petitioner has failed to appear and pursue the matter, this writ petition is hereby dismissed for non-prosecution. What are the IAs?
They have filed a restoration, your lordship. Obliged.
May it please your lordship. This is against an order of removal from service after a disciplinary proceeding.
Yes.
What happened, my lord? Earlier, there was a petition challenging the order of my lord dismissal from service. Then, my lord, the honorable single judge remanded the matter back. The bank authorities, my lord, preferred an appeal. And my lord, appeal was withdrawn, but there was an observation that, my lord, the disciplinary authority will not be influenced by the observations made by the honorable single judge. And thereafter, my lord, the impugned order has been passed.
Where is the impugned order?
Impugned order, your lordship finds at page 105. It's a long order, my lord. May I read it, my lord?
Yes.
In compliance of the order dated 31/5/2023.
105, did you say? It's the order of the appellate authority.
My lord. It was sent back to the, my lord, appellate authority.
All right, yes.
In compliance of the order dated 31/5/2023, I'm reading at page 106, my lord.
Yes.
The appellate committee has reconsidered the appeal dated 6/3/2012 and the submission dated 14/6/2023 of Sri Harimohan Dharikar, so and so. It is observed that major penalty proceedings were initiated against Sri Harimohan Dharikar, and he was served with a charge sheet dated 14/8/2010 for abusing his position for his own pecuniary benefits by posting and passing the vouchers in his own account, leading to overdrawing beyond sanction limit of rupees 5 lakhs on various dates in 2008-9 while working as at Amerigok CRPF branch as service manager during the period from 2006 to 10/12/2009. Further, an inquiry was instituted by the disciplinary authority for looking into the allegations. On conclusion of the inquiry proceeding, the inquiring authority, out of 7 allegations, held 5 as proved, 2 as not proved. After going through the facts of the case and after perusal of the reply of the officer, the disciplinary authority concurred with the views of the IA. Thereafter, the appointing authority and the general manager Guwahati Circle recorded personal hearing to the appellant on 12/8/2011 for making his submissions. Hearing and after independent application of his mind, the appellate authority, general manager, so and so, decided to impose a penalty of dismissal in terms of Rule 67 of the SBI Officer Service Rules. And accordingly, an order dated 19/8/2011 was passed on him by the appointing authority and general manager, so and so. Aggrieved with the order of the appointing authority, the appellant submitted an appeal dated 6/3/2012 against the aforesaid penalty order, which was modified to removal from service in terms of Rule so and so, by the appellate authority, chief general manager, by this order dated such and such. Further, Sri Harimohan Dharikar filed the writ petition 1564 of 2015 before the Honorable Guwahati High Court against the order of the appellate authority. Single bench of the Honorable Guwahati High Court passed an order, white order dated 3/1/2023, and stated that the bank authority shall take note of the present status of the petitioner while considering as to what appropriate punishment would be suitable for the petitioner if the punishment of dismissal from service or removal from service would be unacceptable. Accordingly, the order of removal from service dated 9/8/2012 stands interfere, and the respondents through the appellate authority may pass a fresh order taking note of the entire aspect as indicated above. Against the order of the single bench of the Honorable Guwahati High Court, a writ appeal has been filed by the bank by the appeal number such and such. The division bench of the Honorable Guwahati High Court, by order dated 31/5/2023, has stated that the appellate authority shall reconsider and dispose of the appeal filed by Sri Dharikar after providing opportunity of hearing to him and by passing a reasoned order dealing with the grounds of appeal without being influenced by the findings recorded in the order passed by the learned single judge. In compliance with the Honorable High Court's instructions, a fresh submission from Sri Dharikar was called for regarding his appeal, while later it is so and so. In response to the said letter, Sri Dharikar had made his submissions, while later it is so and so. Thereafter, the appellate committee at Corporate Center accorded personal hearing to the appellant on 10/7/2023 through VC for making his submissions, if any. Sri Dharikar was present before the appellate committee on such and such date and made his submissions. Appeal submitted by Sri Dharikar dated 6/3/2012. with reference to the letter number such and such dated 22/11/2011, 22/8/2011, he appealed to the appellate authority by laying the following few lines for authorities' kind attention and consideration into the unfair inquiry conducted by the bank and inappropriate judgment awarded and favorable action, please. First of all, the appellant begs to state that he could not submit the appeal before the appellate authority well in time within 45 days of the receipt of the order dated so and so because of the following reasons. When he received the order of dismissal, he became so stunned and shocked that he could not react to it and disappointed, so such that he lost his mental control because of his dreams. He had not thought of this unfortunate thing to happen. Hearing this, the old and frail parents fell ill who reside at his place of domicile, that is Allahabad. He had no option but to visit them to console that everything will be fine if he is not guilty. Misfortune struck again, and some miscreants stole his bags in the train, in which there was a laptop, 2 pen drives, proceeds, and orders of departmental inquiry, his personal belongings. There at Allahabad also, he was not feeling well due to mental trauma and felt sick and ailing with various disease and advised rest. Even though he was not well, it is the wish of the parents and their blessings that he is here to appeal before the appellate authority against the unjust and very harsh punishment of dismissal, which is not at all acceptable because he has not done any mistake knowingly or put the bank to loss. The appellant submitted that the main allegations slapped against him is of the instances of his overdrawing in the order of account number such and such, and that all vouchers posted and passed by him, but he brings to the appellate authorities notice that he was transferred from Gitanagar branch to Amerigo DC CRPF branch in August 2008 and posted there as accountant, which is a scale 2 branch. Obviously, he used to pass all the day-to-day vouchers of the branch. Here he wants to mention that most of the vouchers were posted by the clerical staff only, and passing were made by Sri Harimohan Dharikar as he was the only passing officer, contradicting inquiry officials' remark that all vouchers were posted by him. He would like to draw the appellate authorities' attention to one of the major causes of the irregularity caused by the Gitanagar branch, that consequent upon his transfer from Gitanagar to Amarigok branch in August 2008, the Gitanagar branch should have transferred the account of his existing branch, but neither the documents of the OD account to Amarigo branch was sent, nor changed the home branch of the account in the system despite several requests in this regard. The home branch was changed from Gitanagar to Amerigo in the system on 4/9/2009, and the whereabouts of the physical documents of the OD is not known. When it could not be traced out, he formally wrote an application to
So,
the
Mr.
branch.
Chaudhary, just interrupting you for a moment.
Myla.
There was a departmental proceeding initiated against your client.
Myla.
There were 7 charges in total.
Yes, Myla.
5 have been found to be proved.
Yes.
So the penalty was removal from service.
Dismissal initially, my lord. Then it has been converted to, my lord, removal.
Then he challenged it before the High Court.
My lord.
What did the High Court say? Single judge?
Single judge, my lord, I'd like to take
So
your.
just give me the.
It said that, my lord, they had made several observations and said that in view of the observations made, it should reconsider the penalty imposed.
So there is no issue about the departmental proceeding. The fact that 5 allegations have been proved, that cannot be reopened now.
That, my lord, in fact, the honorable single judge has made some observations on that also, my lord, but in view of the, my lord, order of the division bench, perhaps, my lord, those cannot be urged before your worship now.
So only question is whether the penalty is shockingly disproportionate.
Yes, my lord.
Nothing else.
True, my lord.
So there is no need to go into the what is the nature of allegation, etc. So these are.
Yes, my lord, but then one aspect perhaps your lordship will consider that, my lord, there was some procedural irregularities, and my lord, he has also shown in his appeal that, my lord, there are certain guidelines which he has annexed to the writ petition also, my lord. Because of that, my lord, he cannot be.
That is why I am
blamed.
asking, these issues cannot be reopened.
Yes, my lord.
Yeah.
But what I am submitting is that, my lord, no loss has been caused to the bank.
That is a very much important aspect.
So now what is the penalty?
Penalty is removal, my lord.
First round it was dismissal.
Dismissal,
Now it is removal.
removal.
And let us see the single judge's order in the first round.
Mine.
Which page is it?
Single judge's order, your lordship will get at page 79.
Page 79.
Mine. I'll only draw your lordship's attention to certain observations, 2-3 paragraphs, my lord. May I take your lordship to my lord? Page 92.
But the single judge has held that removal from service is also disproportionate.
Yes, my lord.
In paragraph 25,
Yes, my lord.
page 93,
Yes.
there is an observation that removal of service from service is also disproportionate.
My lord.
Still, the removal from service order.
Yes, my lord. In fact, if your lordship kindly
My
read.
lord, what had happened here, my lord, the original order was not set aside. We filed an appeal before the writ appealing in this. The appellate order was there that we should file pass a fresh order, giving him an opportunity. We passed an order, my lord. To the best of our understanding, my lord, that order itself is correct. What he has done, Your Honor, he has taken out money without the sanction, Your Honor.
We are not concerned.
My lord.
Single judge says removal from service cannot be imposed.
My lord.
Has this finding been set aside?
No, my lord.
Then you cannot impose that punishment. As simple as that. Nothing, no argument is required.
My lord, what had happened?
Whatever might have happened. But there is an observation that the punishment of removal from service also appears to be disproportionate.
My lord, that is correct. But the appellate court, while passing that order, my lord, may come to pay 97, my lord. That is the operative part, my lord. Last part. the
Before
appellate-
that, my lord, I'll implore your lordship to read paragraph 26. Page 94. I'm sorry. my
My
lord.
lord, no problem, sir.
No, we'll hear you. We'll hear you. Paragraph 26.
Paragraph 26. Accordingly, we remand the matter back to the appellate authority of the respondent SBI for a consideration as to what appropriate punishment can be meted to the petitioner for the conduct which had been proved against him that he had availed personal loan beyond the sanction limit of rupees 5 lakhs without obtaining any sanction for the purpose, although availing personal loan beyond 5 lakhs was within the otherwise enhanced limit granted by the circular dated 6/2/2008. In doing so, the appellate authority shall also take note that the further charge that the petitioner had fraudulently misappropriated public money was disproved in the inquiry itself. Then, my lord, 28 is the 29, my lord, if I wanted to read.
My lord, this finding is also not correct, my lord. What has?
You take your seat.
My lord.
When your turn comes, you point
Well.
it out. Yes.
Then, my lord, paragraph 29 is the, my lord, final order. We also put on record that the statement of Mr. D. Mozumdar, learned senior counsel, that during the intervening 8 years, the petitioner had led his life taking help from the income of his wife, who is a working person, and his daughter is also employed in the private firm. The bank authority shall also take note of the present status of the petitioner while considering as to what appropriate punishment would be suitable for the petitioner if the punishment of dismissal from service or removal from service would be unacceptable. Accordingly, the order of removal from service dated 9/8/2012 stands interfered. My lord, I am stressing on this word interfered, my lord. And the respondents through the appellate authority may pass a fresh order taking note of the entire aspect as indicated above. Now, my lord, the bank wants to, my lord, submit that it was not set aside. It is only interfered. That is this pen, my lord, perhaps that was submitted. Then, my lord, appellate authority, my lord, the writ appeals order, your lordship will find at page 97.
How old is your client now?
My lord, he is how old is he?
Supposing the writ petition is allowed, can he come join back service?
Yes, my lord. He has got about 4-5 years job. 4 years, my lord.
Yes. Which is the order in the writ appeal?
Order in writ appeal, page 97.
So, my lord, they're trying to take advantage of the, my lord, observation that without being influenced by the, my lord.
This was, your client was not heard when this matter was passed? When the order was passed?
I think it was withdrawn, my lord. Yes, for the respondents, not. It was withdrawn, my lord, in our absence.
Mr. Chaudhary, there is difficulty here. This order of the division bench is creating a problem for the single judge. How can this order, how can the division bench comply with the single judge's order, but without being influenced with the finding? I don't understand. how it can
That's
be.
true, my lord.
So we can't do anything about it. Your client has accepted this. Can this court say that you follow this judgment, but don't be influenced by any observation? What is the meaning of this?
Your Lordship,
Division bench has upheld the judgment, said will not interfere, but don't go by what the single judge said. What is the meaning of this? You address the court on that.
My lord, the problem is.
You address the court on that. You have to file a review against this order. There is no other way out. Law is technical at some stage. Because the findings which now you can rely upon, you cannot even refer to the judgment of the single judge then.
Because of this observation.
And if you cannot refer, you don't have any case. You have to dismiss your writ petition. I'm sorry, this sounds technical, but what is the way out? Look at it logically. Forget for a moment who you are representing. Single judge says these findings are illegal. Single judge says forget this, even an order of removal from service would not be justified. Correct. So therefore you rehear the appeal in the light of these observations. The order is set aside, order of penalty, and you consider the appeal afresh. Means what? You now consider it in the light of observations made in the order. Otherwise, what is there to consider?
Yes, my lord.
Then the division bench says you comply with the order, but don't be influenced with what the single judge says. Then,
Your Lordship is right. But
then how can they?
I'll try to, my lord, to look it from a different angle, my lord. I agree, while agreeing to your Lordship, my lord. Now there is a fresh order, my lord. That order, my lord, your Lordship, in that order, your Lordship may examine, because, my lord, everything has been discussed from my defense to from the charge sheet to my defense, and thereafter, my lord, they have given a finding. And whether that is disproportionate, my lord, without referring to the earlier judgment of the honorable single judge, your Lordship can certainly go into that. My lord, we accept for the time being that, my lord, there was no judgment of the honorable single judge earlier. Then it has come back again to the, my lord, appellate authority. And pursuant to the my lord, division bench's order, the appellate authority has considered. It has considered everything, my lord, from charge sheet to the, my lord, evidence, to my written statement, my defense, and thereafter gave a finding that, my
So
lord.
you mean to say now it has been, the whole issue is reopened.
Yes,
so
my
your
lord.
client can whole hog attack.
Yes, my lord. But then not on the, my lord, other merits, on the point of, my lord, the quantum of punishment. That your Lordship can, in my humble submission, my lord, still go into, without referring to the, my lord, what the honorable single judge in the earlier writ petition has, my lord. Because my submission is primarily that, my lord, there has been no, my lord, loss to the cause to the bank. Of course, my lord, I'll just draw your Lordship attention to the observation in the earlier writ petition that, my lord, there was, although the limit was 5 lakhs, but then there is some other circular also, my lord. I can draw your Lordship attention to that.
So let us once again go back to the single judge's order and then from page 25. Yes.
Single judges of
Page 93. Page 93.
page 90,
25, yes.
96, my. Yes, sir.
A further question would remain as to whether
90,
page 93.
93, my. A further question would remain as to whether having obtained the enhanced limit without an appropriate application would be an act of misconduct, or it would be an act otherwise by an employee. We are not answering the said issue, but we accept the contention of the SBI that the conduct of the petitioner is also a misconduct in terms of the wider concept of the expression misconduct.
even if it was a misconduct, but it has to be understood that it is a misconduct of general nature of much lesser gravity than a bank employee in furtherance of his duties as an employee of the bank doing an unfaithful act of to usurp public money in a given manner. From such point of view, punishment or removal of the service also appears to be disproportionate. He has also referred to the circular that is 6/2008. 6/2008 circular. That, my lord, I have annexed at page 120.
Yeah, but I understood what you will try to say, but I'm just putting you on notice. The penalty given to your client was dismissal from service. Single judge has interfered with it with a direction to reconsider it once again by observing that even order of removal from service would be disproportionate, making it clear that impose any other penalty minus dismissal or removal from service. Correct.
Right.
Division bench in a way affirms it, but takes away that rider of not even removal from service. That is gone. So the order of the single judge is merged on with the order of the division bench.
True.
Division bench order now says you can impose any other punishment other than dismissal from
Yes,
service. Right?
My lord, my lord, perhaps my lord, the division bench said that you can impose any punishment.
Minus dismissal. Dismissal is gone.
Dismissal is gone, removal remained, my lord. Removal remained.
Removal remains.
My lord.
Removal is what they have imposed.
Yes, my lord. Now, my lord, by looking at the order of the appellate authority that has been passed, my lord, after the division bench order, my lord, your lordship may scrutinize that order again, my lord, without being influenced by whatever has been said by the honorable single judge earlier, my lord. We'll assume that, my lord, that order no longer exists. Even then, my lord, your lordship.
No, Mr. Chaudhary, subject to what you say, it's not that the order no longer exists. It has merged into the division bench order.
Yes, my lord.
It's merged.
But then, my lord, division bench says that you can impose any penalty. That is there.
Including removal from service.
Yes, my lord.
So they have imposed removal.
They have imposed the removal of service, my lord. Now your lordship may scrutinize that order, whether, my lord, the removal of removal for service is proper on the facts of that case, my lord.
That order was passed without hearing you, division
Yes,
bench?
yes.
Huh?
Your lordship is right, my lord. The review ought to have been filed there, but that was not filed. In the meantime, my lord, immediately they had passed this order. My lord, of course, your lordship will not go into the, my lord, correctness of this order, but the writ appeal was withdrawn. They had withdrawn the writ appeal, but the observation was there.
Mr. Chaudhary, think about what I'm saying.
I understand, my lord.
You should not rush into.
True, your lordship is right, my.
See, this is a division bench order. We'll have to look at it from that perspective. You can't be just brushed aside.
No, what, my lord, if we take that order in that manner, that will say that
I'm not here to give advice, but perhaps you have to ask for a recall of that order. And if the writ appeal is dismissed on withdrawal, then
whether, my lord,
they will have to reconsider the appeal again. In the light of the observations made by the single judge, that is where the remedy lies for your client. Instead of doing it, otherwise there will be difficulty. You can choose what you want to do. The single judge has passed a judgment, the division bench does not touch it. One only says don't be influenced. That one word, don't be influenced, takes away the protection given to your client. Very, very unceremoniously. And you also do not challenge it.
Your worship will
If that position is restored, then your job is done. Removal from the next is minimum compulsory retirement. Then also he will get some. So that benefit which was given to your client has been taken away in an order of the division bench in an appeal filed by the bank, which was withdrawn by them, and you remain silent. You think this will not have a bearing?
It will have,
When?
it will have. My lord, your lordship will give me some time, my
What
lord.
relief? That relief was taken away in an order passed by the appellate court in the appeal which was withdrawn,
Withdraw.
and there is no reason. If the order was without influence, if that part was not there, then you had your relief. Your relief was there. How old is your client now?
56, no? He's 56, 56, my lord. My lord, your lordship will grant me some time. I'd like to impress upon your lordship.
Think about it. It's
Because, my lord, this a fresh cause of action has arisen, and my lord, without looking into the, my lord, earlier single judge's order, my lord, perhaps your lordship can still go into it. I'll try to satisfy, or my
then
lord,
you argue, then we'll
then
see.
my lord, or maybe my lord will file a review, but then let it be pending for some time, my lord.
No, the reason I'm saying is now they can impose, and the courts views in these matters are very, very. So you are willing to give away an advantage which was there with you and try it afresh. So you want to do it, you do it.
My lord, your lordship
The
will grant.
single judge has given a protection to your client, which was taken away by a one sentence and then.
And without hearing me.
Huh?
Without hearing me.
So this writ appeal has been allowed without hearing you. Practically.
Yes.
And you accept it, and then you ask the single judge to do it once again. You are taking a chance. Do you want to do it? Why you don't prefer a review and get the order recalled and either have it thrashed out there or ask for a fresh decision in the appeal?
Right.
No, I'm asking you.
My lord, that is, I think.
Why you should not do it? It can't be that, okay, I don't feel like I'll not do it. You pass a fresh
No,
judgment.
my-
Can't be that. I need a little.
I understand your lordship, my lord, anxiety.
You may succeed, but you are in a very, very thin line now. Second time they impose a major penalty. You'll be in a very thin line. It has to be shockingly disproportionate. Not only disproportionate,
Yes, my lord.
shockingly disproportionate. I don't know, you may still succeed. You want to proceed, you proceed.
Not today, my lord.
I'll reserve the judgment and
I'll
we'll have a hard look at it. But prima facie, I feel that it's unnecessarily complicating matters.
I'll take some time, my lord, to I can take the right course.
That I agree that this court can still independently assess
Yes.
it. But you have to understand that a relief which you got has been taken away and you have remained silent. And now you want the whole exercise to be done again. And on what parameters? Shockingly disproportionate to the conscience of the court.
On that, perhaps, my lord, I may be able to satisfy your lordship, my lord, but then, my lord, but then, I'll not argue on that, my lord, today. My lord, yes.
You don't want to argue.
My lord. Let me have the instruction, my lord, have a conference with the client, and thereafter, my lord, will come.
Mr. Sahiwala, you withdrew the appeal.
My lord.
And then the division bench took away the relief granted to him.
My lord.
He got that was the relief, one of the reliefs granted to him.
My lord.
The single judge said no removal from service. That relief has been taken away.
My lord.
So. Hmm. So the writ appeal has been partly allowed. Not a question of withdrawal. It has been allowed in part. So that part of the writ appeal which has been allowed and has remained unassailed, can it be now reopened in the writ petition? We'll first go into that question, Mr. Chaudhary.
That will be a big hurdle for
That
me.
will be a hurdle. Because writ appeal has been allowed in part.
True, your lordship is right.
I'm also thinking what to do. We don't want litigants to unnecessarily suffer for legalities. But then law and litigation is all about legality. What do you do? So the division bench says you can impose the punishment of removal from service also.
Any penalty except dismissal.
Yes. And you have accepted that. You have accepted. I mean, technically it will amount to that. Technically it will amount to that. So that area will require a lot of, first you have to deal with that part. Then the question of independently assessing. Can't be that first assess independently and then see what is the effect. Can't be that. They may or may not argue, but then that will come in these matters. In any case, the scope of court to interfere is very limited.
That's right.
And unfortunately, I feel that the writ appeal has been partly allowed. And allowed on a point which is the subject matter today. Paragraph 25 goes.
Then,
And
my lord.
that is exactly what they have done.
Yes.
So it cannot be ignored. The court will have to deal with that aspect.
I get you.
So you, either today or any other day, you have, if you choose to convince the court that that can be ignored, then argue. There is no difficulty.
That I'll not do today, man.
Hmm?
That I'll not argue today, man.
You don't want to do today. But are you appreciating?
Yes, my lord.
Point
Yes,
I-
absolutely, my lord. This we discussed, my lord, because I was not conducting the matter earlier, my lord.
And supposing you file a review and you succeed, one cannot speculate what order will be passed in the review. Then if this observation is deleted, then the exercise is to be done again.
Yes.
Then the single judge's order has to be carried out once again.
My lord.
If that happens, then this writ petition becomes infructuous. So with all these possibilities, what is the point in hearing the matter unless there is clarity? When do you want it?
Let come after 4 weeks, my lord.
Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. Jain, D.K. Jain, Learned Counsel for the petitioner. After arguing the matter for some time, has sought adjournment for 4 weeks so as to obtain updated instruction from his client on certain crucial aspects involved in this proceeding. Mr. A.K. Sahawala, Learned Counsel. You are also there, Mr.
Yes.
Assisted by Mr. W. Sharma. Is present on behalf of members 1 to 6 and does not have any objection and declared available. In view of the above, office release the matter again after 4 weeks.
Lord, if your lordship, he was insisting for a date, my lord.
For a
date fixed.
you agree on a date after 4 weeks?
5th December.
Huh?
5th December.
All right. On the request of both the sides, let this matter be listed again on 5th of December 2024.
Of nice man.
That's all.